from the list that there is someone from Finland. Good morning. And our expert, Matias Zubimendi, is sitting in Spain. Good morning to you as well. And good afternoon for those who are here in China. Can you all hear me? Anybody just say one word so then I know.
Yes.
My name is Ulla Normanniemi, and I'm the Executive Director of Finnish Business Council Beijing. This is the picture of our website front page. And even if you were not our member, you can find a lot of very useful information from our website. The address is below. Up there is a title of Business in China. And if you go to Insights, there's a lot of material doing business in China. Even these slides will be there later. Next slide, please. We are located in the heart of Beijing, just opposite to CCTV, and share the office with the Business Finland, which makes our cooperation very, very convenient. We have been growing despite of COVID, and I think also maybe because of COVID, people and companies feel more like needing each other. And we are very, very happy to serve our member companies, which are both located in Finland and in China. In this picture, you can see our current term board members. They are the essential part of our function. And then I'm working as an operative role in the Business Council. In this IPR webinar, our partner is IPR SME Helpdesk, and this is the second session of the same theme. However, if you attended on the 11th of November, the content is different. So to get the whole picture, you need to listen to both sessions. I can see from the attendee list that there also are or coming companies who will attend our business delegation to Hainan Health delegation next week. So then I also will meet you there either online or offline. But now I will hand over this mic to Jennifer from IPR SME Helpdesk, who will briefly introduce the help desk function before the Matias takes place. And during this session, you can place your questions on the chat box at any time. It's better to keep microphones mute as not to disturb the presentation. And then we will answer, or our expert will answer all your questions at the end of the presentation. Jennifer, please.
Okay, thank you. Good afternoon, everyone, or good morning, everyone. I believe some of you already learned about China IPR SME Helpdesk from last webinar, but as some participants here for the first time, so I just give you a very brief introduction to our organization. China IPR SME Helpdesk is a European Union funded project providing free services and information and first-line advice and training to EU SME to protect and enforce their intellectual property rights in or relating mainland China, Hong Kong, Macau, and Taiwan. EU SME could send us any IP-related questions to the inquiry hotline and receive reply with 3 working days. Our help desk also organizes training seminars and live webinars all over China and Europe. We cover various topic range from basic IP training to tailor-made seminars on specific issue. For example, last time, this is the topic of Medtech Industry. And all these kind of events scheduled in for you can find on our website. Visiting our website, actually, you will find various resource on IP issue, such as e-learning modules, infographic, or case studies, and also a comprehensive library of IP guidelines covering all major IP topics and some industry-specific guides. And that's all about us. And please feel free to send us your IP questions to the inquiry helpline at any time. And next, before give the floor to the speaker, and it's my great honor to introduce him, Mr. Matias Zubimendi. Matias is the IP Business Advisor at China IPR SME Helpdesk. He has a strong background in both business development and IPR protection, as well as extensive experience in terms of the legal affair, patent, and the trademark issue. Now, I give the floor to Matias, sharing his knowledge about main topic of today. Thank you. Matias, please.
Thank you, Jennifer. Welcome, everyone. Let me see if I can control the screen. Yes. Today we are going to discuss how to protect your intellectual property right and your business in the medtech industry in China. This is the content of our presentation. First, I will do a brief introduction about the medtech industry, introduction to intellectual property rights, and then we will proceed with how to protect the business and the most important IP rights involved in this protection. This means trademarks, design patents, domain names, and finally, how to exploit your intellectual property rights, different alternatives, and how to protect and use applications and software as a service in China. So in our previous webinar, we learned how to protect a product, how to develop and protect the IP involved. We learned how to perform research and development and in the proper way, and how to do a due diligence. However, here we're going to, in this presentation, we're going to discuss the business aspects of intellectual property rights, how to protect the name of our company, how our clients see the company, and how our partners will interact with us. But let's do a brief summary about intellectual property rights for those who are in this presentation for the first time and skip the previous one. When we talk about intellectual property rights, we're actually talking about different rights. We have innovation patents and utility models that they protect the technology that is involved in a product or a process. Their requirements, briefly, they are novelty. That means that this technology should be new. The non-obviousness that this new technology shouldn't be obvious for a person who has no technical, who has technical knowledge on the sector. Finally, the industrial application. This means that they should be capable of being applied industrially, to be manufactured industrially. Then we have design patents that they protect aesthetic aspects of our product, how our product looks. We will discuss this later. Also, we have the trademarks that they protect the distinctiveness of a product. This means how a product is going to be recognized by our clients from the ones of our competitors. We will also discuss this later. In the case of copyright, what it is protected is the expression of an idea, not the idea itself, but how it was expressed by a person, by the artist. But in the case of copyright for companies, we should know that software and databases, they are protected in China by copyright. Finally, we have trade secrets and know-how, who are all this knowledge that is not registered, that it is kept as a secret, that has value for being a secret, and it is being protected with some specific measures. Finally, some main principles in order that are necessary to fully understand how intellectual property rights work are the registration principle. Means that if your company has not registered an IP right in China, with the exception of trade secrets, will not have any type of protection. Finally, we have the territoriality principle. That means that the registration done in one country will only grant protection within the territory of that country. This means that any registration that your company has done in Europe will not grant any protection in China, and the same way the registration done in China will not grant any protection in the EU. But how to protect our business? First, we have to make some questions. We should know how our company it is known in China, if this company is famous, under what name this company is famous, why our company is famous. Is it famous because of some specific product, because of the service? What kind of fame? Is it positive? It is negative? All these questions should be taken into consideration. We also have to think how our products look like. Are they well prepared for the market? Are they distinctive enough? Are they, from the marketing point of view, interesting, attractive? And finally, how can my client find me? If they have any issues, they want to get our services, how can they look for us? So for answering these questions and for protecting the intellectual property rights involved in these questions, we have three different intellectual property rights: trademarks, design patents, and domain names. Generally speaking, I always make the advice of including a Chinese marketing team when taking these decisions. When deciding how to create a trademark, how to create a design patent, or a design for a specific product, it's always interesting to have Chinese people that has knowledge on the Chinese market, because the characteristic of the market may be very particular, and it's good to have experts on this field. So when we talk about trademarks, what are we talking about? What is a trademark from the legal point of view? A trademark is any sign that is useful to distinguish our product from our competitors. This means that any distinctive sign will be capable of being protected as a trademark. This means that we can protect the company name, the product name, a logo, combination of colors, anything that helps our product to be distinctive will be capable of being protected. When we talk about this distinctiveness and we talk about the company name, for example, we have to make also a distinction. When we talk about company name, in the case of China, we have to distinguish the legal name from the, let's call it, fantasy name. The legal name is the one that your company will have when registered in China. As you may know, this legal name starts with the city where the company is based, and it's followed by the name that was approved by the government when presenting the company to be registered. Normally, in the registration process, you have to suggest at least 5 names, and the government will choose one. This is the legal name of your company. That may or may not be the same one as the fantasy name. Some companies, they use a different name in order to be known in China. They do it just for most of the cases for marketing purposes. And when they have to deal with bureaucracy, they use, of course, the legal name, but they just, when they create the website, when they create their profile in social media, they just use the marketing name, that it could be also a simplified version of the legal name. In this case, we also have to, I have to point out that when dealing with partners, that they present themselves with these fantasy names, in order to protect yourself and to perform a good due diligence, it's always a good practice to request for the business license in order to know about what's the legal name of every company we are dealing with. This way it's going to be easier to perform a search about their background, and also we will know who we are actually dealing with. In the case of the product name, this can be created by a marketing team. There are no restrictions on that. But in the case of medicine and in the case of drug products, we have to know that it will not be possible to protect those generic names of a drug. The reason is because one limitation to register a trademark is that you cannot register generic terms. You cannot register as a trademark the way that the product it is known in the market. For example, I cannot register the trademark T-shirt for T-shirts. Otherwise, I would be restricting my competitors for explaining what they are selling, what's the product. It's not possible. In the case of drugs, then the generic name, the composition will not be possible to be protected as a trademark. Only those fantasy names, those marketing names that is going to be used for making the product famous or recognized will be possible to protect. But those generic names, they won't. Also, it is possible to protect the shape of a product. If, for example, we are trying to make in the case of drugs again, if we want to create a specific medicine that, in order to be recognized, we have a specific shape, and this specific shape becomes so unique that we could say that people will recognize for them, then it would be protected. How to start the registration of a trademark in China? We have two different alternatives. The first one is going directly with the Chinese National Intellectual Property Agency. This is the most direct way. If your company has no address in China, this means it's not registered and based in China, then you will necessarily need the assistance of a trademark attorney. But if you are already based in China, your company will be capable of doing by yourself. The second alternative is with the Madrid system. The Madrid system is an international agreement that allows companies and individuals to start the registration in their own language, in their own country, with their own national intellectual property agency, and then extend this protection to third jurisdictions. In this case, first there would be an international phase in which the application is sent to the international office, and then we will be resent to each national office of each country that was selected for the Madrid system. After this, it will begin the national phase. This means that the registration will continue with the procedure as if it was presented directly to the national agency. In the case of China, the national phase will have the same procedure as if we presented the application directly with the Chinese National Intellectual Property Agency. What's the main difference, or what could be something to take into consideration when choosing one or the other way? In the case of making the presentation with the Chinese Intellectual Property Agency, we have to know that the full procedure will take in Chinese language. So if your company do not have an expert, this may be considered as an obstacle. that an expert that actually do speak the language. So for these companies, the Madrid system becomes a more attractive opportunity. However, when doing the trademark classification, the trademark classification means that when register a trademark, we have 45 classes. Each class belongs to a very specific type of products. For example, in the case of the class 25, it belongs to clothes. Then we have subclasses. This means that for example, with the same class, 25 is clothes, but then we have one subclass for t-shirts, one for trousers, one for shoes. So when making a registration, we always have to choose what type of products and what type of classes, and what specific products. This means some specific subclasses. These classes and subclasses classification are based on the NIS classification. In the case of Europe, the general and international NIS classification is used. In the case of China, China used the same classification for classes, but a different one for subclasses. So when a company is applying via Madrid system in order to register the trademark, they should check if the subclasses that they are choosing are actually matching the same products in the EU and in China. If not, they just have to make the arrangement, the modification of the subclasses in order to protect all the products that the company needs to have protected. In the case of what are the cost or how to analyze what of these alternatives is more or less expensive, generally speaking, I would say that the main decision will be taken about how many territories the company needs to protect the trademark. If the company needs to make the registration in several jurisdictions at the very first time, then the only or the cheapest option would be the Madrid system, because this way it would be considerably cheaper doing this type of registration rather than going country by country and paying an attorney in each single country. If there's only, or this protection is only wanted in 1, 2, maybe 3 jurisdictions, then I would say that going to the national offices would be considered cheaper and more effective, because you will have an expert on every single of these jurisdictions working the trademark. In the case of China, there's also another topic to highlight, that is the trademark translation. This means that the international name of a trademark, they are translated into Chinese characters in order to make them possible to be read by Chinese citizens, Chinese consumers that do not speak any other language than Chinese. The same way it's difficult or impossible for non-Chinese speakers to read the Chinese characters. For some consumers, they are not capable of reading another alphabet. So in order to make them, to make the products more attractive to them, many companies do this type of translation. That they can be done in 3 different ways. The first one is doing a phonetical translation. This means that the company just replicates how the trademark sounds using Chinese characters. The potential risk of this type of translation is that each character that is going to be used has a very deep meaning, and it's not good for a company to have a negative character or a character with a negative connotation as the name of your company or a product. It would for example, if you have the case of medicine, you use for replicating the sound a character that involves illness, most likely it will not be attractive for a consumer. So it is good to pay attention to what type of characters are we using, which specific characters are we using. The second type of translation is doing a conceptual translation. If our brand is based on a concept, on a very specific word, we could just do a translation of that concept and use it. Finally, the ideal trademark would be a mixture of both types of translation. This means that we keep the phonetical sound of our international brand, so it will be easier to be recognized internationally. But at the same time, we kept the same concept and philosophy of our trademark. In the case of those companies that are very internationalized, it is very interesting to, after we have the trademark registered, to register it with the custom office. This registration is possible to make it online in English, and it is for free. It will grant a huge advantage for enforcement and specifically for surveillance, because after it is registered with the custom office, every single product that is being imported or exported from China and going through the custom office will be checked if they have one of these registered trademarks. If one of the officers finds out that the product contains our trademark and is being trying to be imported or imported, will notify our company, will stop the products for a period of 3 days and notify our company. Then we will have the chance to take a decision if we want to take further actions and enforce the intellectual property rights, or we just dismiss this product and they continue their way. So what's the main advantage? That doing this registration, we will have someone proactively checking if there are products being exported or imported using our trademarks, and considering that this can be done online and for free, I believe the effort and the profits are significantly high. So my advice is to always, when we have a trademark, to register it with the custom office. But let's discuss about how to protect our designs, how to protect how our products looks like. With design patents, what we are protecting is the aesthetic and ornamental aspects of the product. It's only how they look, how it is presented. There is no function on it. So in this type of protection, we could include the packaging. This means how the box of the product looks like, how it is presented, how the users of for example, the consumers of a product will see it on the shelves. Also, we could protect how our product looks like, its shape, its how it is presented. In the case of software, we will also be capable of protecting how our we will also be capable of protecting how our software looks like in a phone, in a tablet, in a computer, how everything is distributed in the screen. This also will be possible to protect it by design patent. We have to understand that here we are only protecting the ornamental aspect. So if, for example, in the case of a product shape, the shape has a very specific reason that gives an advantage. Let's say, for example, a very specific type of peel, that the peel has a shape, and this shape is more useful, makes the content easier to be absorbed by the body, then this type of innovations, they have to be protected by innovation patents, not by design patents. If there is any functionality, then we have to go to, again, innovation patents or and maybe utility models. But if it's only how it looks, it's design patent. And then we have to distinguish, do we protect it by, when it's very characteristic, do we have to protect it by trademark or by design patents? Well, my advice would be to make both type of registrations. If the product shape is unique, then you will protect the design with the design patent. However, if you realize that this design is so unique that actually helps your product to be distinguished from your competitors, and for this design, it would be possible to make a similar version of it, then I will protect it also by trademark, because this way we will be protecting not the specific design itself, but also the main characteristics, and made the protection a little bit broader and kept competitors away from trying to steal this type of designs. In the case of the requirements, again, we have to know that it's non-functional. Any function of the design will go eventually to design patent, to innovation patents. And finally, and most important, we have to know that novelty is one of the requirements for design patents. This novelty is global. So before disclosing any design, and for example, to attending a trade fair or to uploading the product online, we should already have done the registration. What are the main differences between design patents in China and the EU? The first one is the term of protection. While in the EU, the protection lasts for 25 years. In the case of China, it will last for 15 years. We have to know that this term of protection was modified recently, 17th of October 2020, with the new patent law. Before it was 10 years. So now they last longer. In the case of unregistered design protection, in the EU, we have a 3 years period of protection for those designs that were never registered. And in the case of China, if there is no registration, there is no protection. Remember the registration principle. So this is a very significant difference, because some companies in the EU, they don't even bother to make any design protection or registration, sorry, because they know that they have a 3 years period, and after those 3 years, they will be using just a different design, so they don't even invest in this type of registration, knowing that they will be covered anyway during this time. But in the case of China, it won't be the case. You will have no protection. Another difference is the limit of designs that you can include per application. In the case of the EU, there is no limit. In the case of China, you could only add 10 designs per application. Of course, you could add more, but you will have to pay more. And finally, there is a difference with one of the requirements, novelty. In the case of the EU, it's global, but there is a grace period of time. It would change depending on the jurisdiction, but generally speaking, there is a grace period of time in which, if your company disclose the design for example, in a trade fair, then there is a grace period for doing this registration, and the novelty will not be affected. generally speaking, it's 6 months, a 6 months grace period. In the case of China, it is also global, as I mentioned before, but there is no grace period. When the design is disclosed, any protection is lost, if, of course, there is no registration. Another intellectual property right are domain names. The domain name is your address, the address of your company online. Why it is important to protect the domain name in China? And when I'm saying in China, I mean it by the .cn. First, because as you may know, there is a whole ecosystem in the Chinese website. In China we don't have Google, we have Baidu, and the searches that we can find may be just different. So if your company wants to have more presence in China, it is advisable to have a Chinese domain name with the country code that is going to be easier to be found by the Chinese search engines. So in this way, your company will be more visible. It is also advisable to have a website in Chinese language using this country code. So also will be more consumer and partners friendly, would be easier for them to read and understand what type of products are we offering. Here we have to discuss with the common practice of scams that we notice that happens quite often when registering a trademark. Sometimes companies, after doing the trademark registration, they receive an email saying that someone is trying to register the domain name using the same name of a trademark, and if you want to avoid losing this domain name, that you can do the registration directly with them. This is a very common type of scam. My advice is always to avoid and ignore this type of emails. Do not pay attention to them. And if your company wants to have the protection and take this opportunity as a warning and proceed with the registration, do it, but not with the person who sent you the email. Do it with your own agent, with your own people, and you will know that you will have a better service. But what happens if someone already took our domain name? There are two different types of dispute resolution methods. The first one is the one that is organized by WIPO, by the World Intellectual Property Organization. This method is internationally recognized and it's working in China since 2019. It's very easy to continue with this, so to proceed with these rules. You even have samples of all the writing statements that you will need available on WIPO website. The rules are very simple. You can only take down those domain names that are being or were registered in bad faith. And in the case of China, you will only be possible to do this WIPO procedure for those domain names that were registered in the last 3 years. In order to check if there is bad faith, your trademark or having your trademark registered is going to be useful, but it's not going to be enough, because as I mentioned before, in the case of a trademark, we have different classes. We can protect one brand for one class and leave it available for all the different ones. This means that it could be different companies having the same word registered as a trademark in different classes, and they can all coexist. There's no confusion among their consumers, and there is no problem and dispute. However, in domain names, we do not have classes. The person who registered the domain name first already has the rights over it. So when we are talking about dispute resolution methods, we have to know that the trademark will be only a priority or a reason why the other person may be using or may be registering in bad faith. But it could be the case that the other company they also have the same brand registered, they register the domain name, they are using it for offering their own services, and we won't have the chance to obtain that domain name. So again, here it is important, or what I'm trying to say is important to register it as soon as possible. In the case of the Chinese regulation themselves, you can only recover a domain name by unfair competition of the person who made the registration, and the jurisdiction is going to be, or the easiest and faster jurisdiction is going to be the internet courts, that are a new court where all the procedure takes place online. It's very fast because on average, each case is solved within 27 days. So, and the jurisdiction is very specific and restricted to certain topics, and domain name registration is one of them. So this would be the easiest and faster alternative for dispute resolution. Finally, one last thing to take into consideration with your Chinese domain name and your Chinese website is please pay attention on what type of information you're uploading, and do not include trade secrets. This means sensible and secret information on the website. Otherwise, the registration may be lost. Regarding how to exploit your intellectual property rights or alternative ways of exploiting intellectual property rights, the most common one would be the license. License allows the usage of a specific intellectual property right by a third person. And when doing these licenses, we have to take special attention to some specific clauses. The first one is the territoriality. Remember the principle of territoriality. When we allowing someone to use a trademark, we have to limit to what territory. This is particularly important for those companies that has the trademark registered in several jurisdictions, and they want to avoid parallel exports from one territory to the other one. So we could say that the company has the permission to use for example, a trademark or a design in mainland China, but not could be Vietnam. And again, remember that in China we have 4 jurisdictions. We have mainland China, Hong Kong, Macau, and Taiwan. So we could limit the license to mainland China and give it to another company in Hong Kong, and even give it to a third company in Taiwan. And this would be perfectly possible. So take into consideration when giving a license, choose to which territory this license will apply. Another important clause is the exclusivity. Means that if you give an exclusive right to a company, this means that you won't be able to give a license for the same intellectual property rights to any other company. So this has to be taken, or this decision should be made carefully. Then we have the extension, the time extension for how long the license will be valid. Then we have to include control clauses. This means clauses that allows the company to perform controls, and even would be ideal to have the possibility of approving or not certain specific uses of a trademark in order to have more control of what the other company is using for when actually using our intellectual property rights. Finally, there should be a clause about sub-licenses, allowing them or not. If we allow a company to sub-license, this means that potentially our intellectual property rights will be in the hands of companies that we don't know. So my first advice would be to avoid sub-license, the possibility of sub-licenses, or limit them with the need of a prior approval from your company. Please take into consideration that with the new patent law, there is the possibility of registering a patent, innovation, or design in an open license system. This means that anyone who wants to use our patent just will go to the Chinese National Agency and pay the fees and receive a non-exclusive license. This new technique, or this new open license system, is quite new, so we haven't seen yet any case and how exactly it works. But we know by the law that we will provide certain advantages for the company, because there is a reduction on the annual fees that we pay for patents if they are available for open license. And we believe that will give companies more profits, because it will incentive the registration, and it will incentive that companies they're not scared of any competitor, and they just want to make profit from the IP right. They will protect it and offer it for open license, and this way obtaining royalties without having an active presence in China. Finally, we have to discuss franchise. In the case of franchise, what we are licensing is the business method more than the intellectual property rights. However, we also will be licensing specific intellectual property rights. However, in the franchise, what we are also transferring is the know-how and trade secrets. So it's very important to have the chance to perform quality control of the entire franchise, to check who is doing and what with our company name, because when we have a franchise, actually someone will be using our name, and they will present to our consumers as if they were our company. So
Matias,
yes.
Just a break that we have less than 10 minutes to go.
Okay, then I will go faster. Another method of exploitation is partnerships that will give synergy and in research and development, and you will be able to join another company and get profits and advantages by cooperating. We have some conflict resolution alternatives. My first advice would be to avoid litigation as possible, or always try to negotiate. There are two different approaches. The first one is a stick, that when you discover that someone is infringing our IP rights, directly go and sue them, or file a lawsuit and try to fight back the infringement. But there's another alternative, that is the carrot alternative. We call it carrot, that when you see an infringement, you just try to communicate with them and say that you don't want to start a lawsuit, and if it will be possible to solve the situation with the license. And this way you will transform a problem into a solution. Instead of having a lawsuit, you will have a source of income with the license. In the case of enforcement in China, you have three different alternatives: people's court and intellectual property rights, which are courts with specifically expert with judges that are expert on this specific topic. And then we have the internet courts that I mentioned before, that they are for very specific cases, and the entire litigation procedure takes place online. And finally, regarding apps and software as a service, we have to know how to protect our software. I already mentioned that the software itself is protected by copyright, maybe by innovation patents, in the case that the software will solve a technical problem. Then it will be possible to protect it by innovation patent, but this will also involve the usage of hardware, so it's very specific. In the case of your business, what you will be protecting is not only the software, but more as your software as a service and the intellectual property rights. Again, here we have the trademark, how is what's the software name, your company name involved in the software. Then you will have the protection of the design, how it is presented to the public, how it looks in an app, in a cell phone. This can be protected by design patent. And you will be able to exploit this intellectual property rights by offering the service, the service with the software, or directly by allowing certain companies to use your software in their own service. Finally, some other important aspect with using Chinese apps that sometimes is not considered an intellectual property right itself, but in my opinion, it's very important, is to create corporate profiles and have social media present, because at the same way as that happens with domain name, the first one to do the registration will be the one with the priority. And since several, or the same brand can coexist in different classes even if the owners are different companies, it is very important to be the first one having the corporate profile and how can consumers look for our products online. Finally, some takeaway messages to protect your business: always register your trademark and translate them, register your designs, protect your unregistered designs as trade secrets till the moment they are not registered. They will only have protection via trade secret, and if they are disclosed, any protection is lost. In the case of exploitation, always license your intellectual property rights to non-competitors and obtain profits. Negotiate before enforcing and try to avoid litigation as much as possible. But if you cannot avoid litigation, choose the fastest enforcement alternative, in that, in my opinion, when possible, would be the internet courts. In the case of software as a service and Chinese apps, create your social media profiles when registering your company name. Try to exploit your services by offering them to non-competitors, and always use Chinese language. This way will be easier for Chinese consumers to understand and use your software. If there is any doubt, you can contact the China IPR SME Helpdesk. Here you have our email. We normally reply within 3 working days, and all our services are for free. So let's proceed with the Q&A section, if we still have some time.
So participants, do you have any questions? If not, I could ask a couple of present questions. Is that okay?
Yeah.
So first question, is it okay to register my English trademark now and later think of the Chinese version of the trademark? Any risks with this strategy?
Well, in this case, your you will have a priority over your international brand. However, everything will be reduced to how your company and your products are famous in China. If they are famous by the Chinese name and someone registered the Chinese name, you won't have any possible protection because it would be very hard to link the international name to the Chinese version. So in my advice, it won't be strategical to do this type of approach. I would do the registration at the same time, and even if it's not possible because of the budget, what I would do is to combine the English and the Chinese name in the same registration. So for the same price, you will have both names included, and this at least will grant certain level of protection.
Okay, thank you. Then there is other question related to health and wellness application.
Mm-hmm.
I have created a health and wellness application that allows people to track and monitor relevant health data and receive recommendations from experts. This application, APP, has a distinct design, which I don't want my competitors to use. How can I protect the design of my app?
Well, in this case, with the design patent, how your software is presented in the screen to the consumers, to the users, this can be registered with the design patent. In the eventual case that there is a functionality on this design, we could discuss if we can protect it as innovation patent, which is highly unlikely because normally it includes the usage of hardware in a very specific way. But as a design itself, it will be registered with the design patent. It will be protected with design patent.
Okay, thank you. And then one more question. There is a question, I don't think I qualify for a software patent. And in case of copyright, my idea will not be protected. How can I best protect my new healthcare solutions designed to manage patient care?
If there is no possibility of innovation patent, then and copyright will not grant you any protection, then the most advisable alternative would be to protect it as a trade secret. Everything that will be shown, this can be protected by design patent. But everything that is on the software that has a very specific usage or gives you an advantage, then my advice would be to protect it with the trade secret, to keep it encrypted as much as possible and to make it harder for competitors to check it as much as possible. Of course, this type of protection is not ideal and it won't last forever. However, it's the alternative that your company has.
Okay, thank you so much. It's time to thank you. Thank you, Matias, so much about this valuable information. And if there is no other question, we will end now. But I would still remind all the listeners that on the slide in front of you, you can see the China IPR SME Helpdesk addresses. And I will send the slides to you later. So feel free to contact them because all the advices are free of charge. So any questions you have related to this IPR protection of your health tech or services. Thank you and have a nice day and have a nice evening.
Thank you. Bye-bye. Have a nice day and an evening. Bye-bye.